I'm Michelle Smart. I'm an enrolled agent, and I wanted to go into a little bit more detail about how to respond to a letter from the IRS that is a denial of the ERC. And don't feel alone out there if you got one of these, because they just got sent out to a ton of people who should not really have gotten them. I wanted to share with you some of these articles that have come out recently first, and that is, here's one in the Wall Street Journal, where the tax advisors keep citing mistakes and denials of employee retention tax credits. This is what we've been saying all along. They continue to do this, sending out denials to people who are in business, and they're just so many mistakes. It's unbelievable. And here's another article that came out on August 1st in Bloomberg Tax. And this is referring to the Chevron ruling and how it may affect the ERC. We've talked about this before. They overturned the Chevron Act, and what that means is the IRS has less power to narrowly define how you qualify for the ERC. And specifically in this article, he's referring to Notice 2021-20, which is the main notice that was put out by the IRS that tells you how you qualify for the employee retention tax credit. So let's go over this letter of denial. So it looks like this: we cannot allow your claim, and it gives a reason why. It's really important to look at the reason why, because that's what you're responding to. Now, a lot of these are the same here. Based on the review of IRS records, we've determined that you aren't an eligible employer for purposes of the employee retention tax credit because you weren't operating a trade or business during the periods shown above. Yada, yada. Okay. So you usually have 30 days to appeal, and if you need more time, then just call the IRS. A lot of the people who got the denial letters did not get this one section that they were supposed to get. The IRS is required to let you know with the taxpayer rights that you have the right to appeal, and they are supposed to include this section, which if your letter of denial did not have this section, that's why I'm going over it here, so that you know how to appeal the letter. So if the amount is under $25,000 per quarter, you can do a small dollar case appeal. And you have 4 steps. Prepare a written statement that you want to appeal to the Office of Appeals. List the tax periods or years disallowed, why you disagree with it on each item. 3, provide your name, address, taxpayer ID, daytime telephone number, and a copy of this letter. And 4, mail your appeal request to the address at the top of the first page of the letter. Now, if the disallowance was for a quarter that exceeded $25,000, then you have to prepare a formal protest. It requires a little bit more information. Prepare a written statement, list the tax periods and the items that you don't agree with, your name, address, ID number, phone number. Include a detailed statement of facts with names, amounts, locations, etc., to support your reasons for disputing this disallowance. One general rule of thumb with anything with an audit or the IRS requesting information: address only what they have asked you for. So if they said you were not in business, don't send them your whole file. So if they say you were disallowed because I want to see your PPP that was deducted, then send that, but stick to what they asked for, okay? 5, if you know the particular law or authority that supports your position, identify that law or authority by providing a legal citation. Sign the perjury statement below and include it with your written appeal. If your authorized representative prepares the request, he or she must sign it. Mail it to the address at the top. Always mail these things, return receipt. All right, here is the letter. I apologize in advance to people who are better at secretarial work than I am. But anyway, this is a notice of appeal, my name, my phone number, because I'm the representative to the IRS. Always note the letter number that's on the top right of the letter. And this is a letter 105C, EIN number, ERC claim, tax periods, company name and address. To who it may concern, we are in receipt of your letter of disallowance for these periods. Now, here's another mistake the IRS made. And I only found this out because I have a POA and I logged into TDS, which is Transcript Delivery System online for the client. The client received 2 letters of denial for fourth quarter 2020, 1 letter of denial for second quarter 2021, and no letters of denial for first quarter 2021. And I found out when I looked at their transcripts that they had a disallowance for first quarter 2021. So I have to address that in the letter. We got 2 letters for fourth quarter and no letter for first quarter. Upon looking at the transcripts, I noticed there was a denial listed for first quarter 2021 and no letter was received, and therefore I do not have a letter ID for that. Your denial stated the reason for denial was the company name company name in there, I didn't leave for you. Was not operating a trade or business during the periods listed above. Your own transcripts show 941 forms processed and tax payments received for those same periods. Those payroll records are in your system as proof that the company was in business during the periods mentioned. In addition, you have processed forms 1120S for the years 2020 and 2021. Those are their tax returns. I have included for your convenience the following documents. Now, again, this is to back up what the IRS claimed they were not in business. So this is proving that they were in business. The 941s for all the periods, sign these, always sign them. Don't send unsigned forms to the IRS. The transcripts that I had, I'm sending in to show them, yes, they were in business. There's the 941 and tax payments. The 1120S, the tax returns. The 2 letters received from the IRS, again, noting no letter was received for first quarter. My power of attorney, this is on file. And under penalties of perjury, like it said there, I'm going to sign it and the company is going to sign it also. So, so you can use that letter if you like, if you're denying for the same reasons, but be sure to respond to the reason for the disallowance. And it should be sent within 30 days. Again, I can't take legal responsibility for any advice I give online. So check with your tax representative or take personal responsibility. I have to make that disclaimer. So this is how you respond to a denial. Stick to what they denied you for, the reasons for denial, and make sure that you get it to them. Always send these things, return receipt. The advantage of having a power of attorney with a tax professional is they can check to make sure that all your quarters are okay. The IRS has made so many mistakes that I have seen with my clients that it's really advantageous to check the transcripts. Again, it'd be great if you would like and subscribe, and so that this directs other people who are needing this information to find my website. Thanks again for watching.